Washington, D.C. is once again at the center of a heated debate, this time over crime, justice, and the limits of self-governance. Congressman Byron Donalds has introduced the D.C. Crimes Act, a bill that challenges how the nation's capital handles youthful offenders. The fight pits Congress against local leaders, raising questions about crime, accountability, and democracy itself.
Now I'm going to recognize the sponsor of the bill, Mr. Donalds, for 5 minutes.
Thank you, Chairman Comer, for bringing the D.C. Crimes Act before committee. Crime in the nation's capital has really been a stain on this great city for far too long, and it's really the responsibility of decades of really weak leadership has allowed it to spiral out of control. Rather than focusing on cleaning up the city and making it safe for residents and visitors, district officials and the D.C. Council have refused to enforce the law. They've put criminals back out on the street and have continuously pursued progressive, soft-on-crime policies. For instance, the crime data shows that juveniles make up the majority of violent arrests in D.C., from crimes like robbery and carjackings. And instead of addressing the clear epidemic of youth crime in the city, the D.C. Council increased the age of youth offenders to individuals 24 years old and younger. That means fully grown legal adults in the District of Columbia can receive sentences meant for children. This is patently insane, and Americans across the board are sick of this kind of absurdity. Since the D.C. officials have not only known about the city's crime issues for years, but have actively aided and abetted the continuance of it, Congress has a duty, and I stress this again, as the federal enclave, Congress has a duty to step in and restore law and order to the capital city of our great nation. The president's actions and immediate decline in crime show that lawlessness is a choice, and we do not have to live with that choice. This is why I've introduced the D.C. Crimes Act. Simply put, my bill lowers D.C.'s definition of youth from under 25 years old to under 18 years old. 2, it removes the ability of judges to sentence youth offenders below the mandatory minimum, therefore deterring juvenile crime. And 3rd, it requires the District of Columbia's Attorney General to establish a public website containing much-needed statistics on juvenile crime in Washington, D.C. It is our constitutional duty as members of Congress to oversee the acts happening within the District of Columbia. This is something that's really been going on for far too long. The city has not responded to what has clearly not been in the best interest of the nation's capital. And I know that there's many arguments about home rule when it comes to DC, but it should be remembered at all times that our Constitution in this matter is clear. The district is a federal enclave. It is a federal enclave. That has not changed since the founding of the Republic. And so if the DC City Council, not its residents, if the DC City Council will not do what is necessary and appropriate to make sure that the Washington, D.C., the nation's capital, is safe, then it is a requirement of Congress and the President of the United States to do so. Thank you, Chairman Comer. I yield.
Chair now recognizes the ranking member.
Thank you, Mr. Chairman. This is just, of course, another attempt by this committee to disenfranchise over 700,000 taxpayers of the District of Columbia and their ability to write their own laws to govern their own city and community. Now, this committee, of course, has now spent more time interfering in DC's local law affairs than almost any other issue. This bill, of course, is trying to amend the Youth Rehabilitation Act. Now, the DC Council's bill, just to be clear, was the subject of months and months of hearings, community meetings, considerable debate. Folks from the neighborhoods actually came together as they worked and crafted this actual legislation. Now, the considerable debate among DC's residents and their elected representatives should be considered in this moment. That's the way democracy works. And if DC residents don't like these policies, they can vote for new policies or they can vote for new representatives at the local level. Our committee is not talking about violent crime in Louisiana or Mississippi or Alabama or other places, or federal issues that are important to us like gun violence, or even enforcing the laws that are currently on the books to keep guns out of the wrong hands. But let's talk about what this Republican bill would actually do. The DC Crimes Act amends DC's Youth Rehabilitation Act, which allows judges to give alternative sentences to young adults and to seal their conviction records. Now, my Republican colleagues on this committee from Alabama, Florida, Michigan, New York, and other places have laws in their states similar to this actual Rehabilitation Act. The sponsor of this bill, of course, from Florida, and we should actually examine Florida's Youthful Offender Act. Florida first enacted this law in 1978. That's 7 years before D.C. enacted this law. Under Florida's law, a person cannot be sentenced to more than 6 years in prison. Under D.C.'s law, there is no ceiling. In fact, the D.C. law is stricter. Now, under both Florida and D.C.'s laws, mandatory minimum sentences can be waived. But the D.C. Crimes Act repeals the mandatory minimum waiver, which would be stricter than in Florida. Under D.C.'s law, the maximum eligible age for alternative sentencing is 24. That is higher than Florida's maximum age, which is 20. The D.C. Crimes Act lowers the maximum eligible age to 18. So to be clear, D.C.'s maximum age is not only an outlier, but the maximum eligible age is higher than in Michigan than in D.C. And the list goes on and on for different states across the country. Again, regardless of what you think of this bill, we'll continue to take away the rights of the elected officials that represent this community and continue to move back the progress this community has made through numerous meetings and debate of the council. We oppose this bill, and I yield back.
Gentleman yields back. I'll recognize myself now for 5 minutes. I support H.R. 4922, a bill providing common sense reforms to the District of Columbia Criminal Code. It's clear to members of the committee and the public that D.C.'s soft-on-crime policies have failed to keep D.C. residents and visitors safe. The D.C. Crimes Act overturns targeted portions of the D.C. Council's Youth Rehabilitation Act by amending the definition of a youth offender from a person under the age of 25 to under the age of 18. Let me emphasize D.C.'s current law. Currently, D.C. Code allows a criminal under the age of 25 to be given the same leniency that is afforded to minors. This bill requires that we treat adult criminals as adults, like the rest of the country. It also removes judicial discretion to sentence youth offenders under the minimum sentencing structures in place. Our capital cannot continue to let criminals freely roam the streets and expect this crime crisis to end. As juvenile crime soars in the district, the bill also requires the D.C. Attorney General to create a publicly available website that better tracks juvenile crime data. This data will inform Congress, the district's elected officials, the Metropolitan Police Department, the public, and others on the severity of juvenile crime in the city. Citizens of D.C. and visitors to our nation's capital deserve to feel safe. I want to thank Representative Byron Donalds from Florida for leading this effort again this Congress. I encourage my colleagues to join me in supporting this legislation. Do any other members seek recognition? Seeing none, I'm sorry, Ms. Norton. You're recognized for 5 minutes. Ms. Norton from Washington, D.C.
I strongly oppose this undemocratic and paternalistic bill, which amends D.C. law. The over 700,000 D.C. residents, the majority of whom are black and brown, are capable and worthy of governing themselves. I ask unanimous consent to enter into the record letters opposing this bill from D.C. Mayor Marion Bowser, the entire D.C. Council, and D.C. Attorney General Brian Schwab.
Without objection, so ordered.
While the D.C. Crimes Act is an irredeemable bill, I want to note one positive change to it. As introduced, this bill would have prohibited the D.C. Council from increasing or decreasing criminal penalties. That provision is not included in the version of the bill we are considering today. The substance of this bill should be irrelevant, since there is never justification for Congress to legislate on local D.C. matters. However, I will discuss it. Republicans repeatedly say D.C.'s Youth Rehabilitation Amendment Act leads to adults being treated as juveniles. That is false. The sentencing alternatives and set-aside options in the Youth Rehabilitation Amendment Act apply in adult court to individuals under the age of 25. not juvenile court. Judges may, but are not required to apply the Youth Rehabilitation Amendment Act. The Youth Rehabilitation Amendment Act is not available for certain crimes. DC is the only jurisdiction with a so-called young adult offender law. Alabama, Florida, Michigan, New York, South Carolina, and Vermont have such laws. The sponsor of this bill is from one of those states. The Revolutionary War was fought to give consent to the governed and to end taxation without representation. Yet DC residents cannot consent to any action taken by Congress, and they pay full federal taxes. Indeed, DC pays more federal taxes per capita than any state, and more federal taxes than 21 states. If Republicans cared about democratic principles or DC residents, they would take up the DC Statehood Bill, H.R. 51, the Washington, D.C. Admission Act, which gives DC residents voting representation in Congress and full local self-government. Congress has the authority to admit the state of Washington, D.C. It simply lacks the will. I urge members to vote no on the D.C. Crimes Act. I yield back.
Do any other members seek recognition? Seeing none, the question is now on the amendment in the nature of a substitute. All those in favor signify by saying aye. Aye. All those opposed signify by saying no. In the opinion of the chair, the ayes have it, the amendment is agreed to. The question is now unfavorably reporting H.R. 4922 as amended. All those in favor signify by saying aye. Aye. All those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it, and the bill is ordered favorably reported as amended.
Recorded vote, Mr. Chairman.
A recorded vote is ordered as previously announced. Further proceedings on the question will be postponed.
Byron Donalds argues that crime in Washington, D.C. has spiraled out of control due to decades of weak leadership and soft-on-crime policies. He points to data showing juveniles make up the majority of violent arrests, particularly in robberies and carjackings. His central claim: D.C. laws allow individuals up to 24 years old, fully grown adults, to be treated as youth, receiving sentencing breaks designed for minors. Donalds insists this leniency fuels lawlessness, and that Congress has a constitutional duty to act because D.C. is a federal enclave. The legislation proposes three major changes: redefining youth as under 18, not under 25. Eliminating judges' discretion to go below mandatory minimum sentences for youth offenders. Requiring the D.C. Attorney General to publish detailed juvenile crime statistics online. Supporters argue these reforms will deter crime, restore order, and bring the Capitol in line with national standards for criminal accountability. Democratic members of Congress strongly oppose the bill, calling it an attack on D.C. home rule. They emphasize that the Youth Rehabilitation Act was the result of months of hearings, community meetings, and debate among local residents and leaders. They argue that other states, including Florida, Alabama, Michigan, and New York, have similar youthful offender laws, some even more lenient than D.C.'s. Critics say the bill undermines democracy by stripping 700,000 D.C. residents of the right to govern themselves. D.C.'s Delegate Eleanor Holmes Norton condemned the proposal as paternalistic and undemocratic. She pointed out that D.C. residents pay more federal taxes per capita than any state, yet lack full voting representation in Congress. Norton argued the real solution is not outside interference, but D.C. statehood through the Washington, D.C. Admission Act. She urged lawmakers to respect the will of the people and their elected council. The committee ultimately voted to advance the D.C. Crimes Act, despite fierce opposition. A recorded vote was ordered, setting up a larger battle in Congress. This clash raises fundamental questions. Should Congress impose its will on local D.C. matters, or should residents decide for themselves, even if crime remains a pressing concern? Before we continue into how this could reshape the larger debate over law, order, and democracy in America, make sure to hit that subscribe button and turn on notifications so you don't miss future breakdowns of critical political fights shaping our nation. The D.C. Crimes Act is more than just a crime bill. It's a test of governance, accountability, and democracy itself. On one side, a push to crack down on violent crime with tougher laws. On the other, a defense of local autonomy and the rights of D.C. residents. As this battle moves forward, the outcome could redefine the balance between federal oversight and self-rule in the nation's capital. The stakes couldn't be higher.